But I'm Dan Siciliano again. Thanks very much for attending. So my lunch talk is a little bit on and off topic. So what I've been charged with doing is trying to draw at least a dotted line between the world of kind of the specific trees of I-9 compliance, workplace, I-9 auditing, and all the related issues that surround that complex topic, and draw some connection. And I think it's actually a really profound connection, so I'll be happy to answer questions as we go into it, but draw a connection between those issues and the practical realities of securities regulation, securities class action lawsuits by shareholders, regulatory action by the SEC, and somehow an explanation as to why we haven't really seen this yet. So why worry about it if we haven't seen it yet? And as a preface to my kind of theory on this, I'm going to say, think back 10 years, or even 5, and ask yourself the question, did you know what FCPA was? And did you think it would fell several Fortune 1000 companies? Or that the total costs and fines would exceed $11 billion thus far in the last 5 years, right? We didn't know what FCPA was unless you were kind of nerdy like me and followed this stuff before it really mattered, 5 or 10 years ago. Do you remember options backdating? Who really thought about options backdating as a complex matter before about 2005, 2006? So these are issues that I think could come to the fore in the context of I-9 compliance and could be quite meaningful. And I want to kind of outline why, and then we'll have a little bit of discussion. So I must say at the beginning that this is relatively speculative. I don't think we've seen much of this. We've just seen a little bit of it emerging. And I'm going to try to, as is, my ability to do without being held to, I like to say, well, thank goodness I don't actually practice immigration law. All I do is I teach at a law school, so I get to say lots more stuff than an practicing immigration lawyer could. So, none of this stuff is particularly legally exacting yet. It's more speculative. But first I want to highlight something. I get this question a lot, which is to say, Dan, we have a lot of stuff on our plate to worry about, whether you're an outside counsel, a general counsel, or actually a board member, or advising one of those people. I get a lot of comments that go along the lines of, this is something that hasn't happened yet, so we don't have the bandwidth or the time to spend a lot of attention on it. It's a perfectly reasonable statement, but I want to identify a lot of the interesting scientific research that's going on at Stanford, typically outside of the law school, surprise, surprise, that talks about why it is that high-powered, important players in the corporate community, in the academic community for that matter, in the regulatory world, are blindsided by stuff that a couple years after it starts to happen, everyone says, well, how come you didn't see that? And there's some really specific cognitive and neurological reasons why that is. And so to try to capture the post-lunch crowd without letting you nod off, I'm going to talk a little bit about a couple of interesting things. So there aren't any massive multitaskers in the corporate environment. So here's something that Stanford did that was really interesting, and that is they tried to find people on campus and identify a modern fact of everyday life for all of us. So how many people have, in the last 2 weeks, been on a conference call or a phone call that wasn't a conference call and also checked your email or your BlackBerry? Come on, fess up. All of us, right? Every single one of us. All right, so there's this idea on Stanford campus going back about 4 years ago. They said, all right, some people have got to be pretty good at multitasking. Other people aren't so good. And maybe there's some super multitaskers out there who can super juggle everything like you do every day. And the reason this was a really interesting question is because we see students do it. We see directors at board meetings do it. We see lawyers do it in court, in meetings, at advisory critical moments. You name it, people multitask all the time. And so the question was, can people actually engage in sufficient multitasking to get important things done? This is, in fact, the first 2 steps of the argument I'm going to make as to why we're likely to be massively blindsided by the kind of coming wave of I-9 compliance-related liabilities. So first, let's see if I can manage to do this. Shift-tab? Is it Alt-tab or Shift-tab? Alt-tab, all right. Aha, oops, I messed it up. Look at that. Hang on. There. Okay, so the first thing we're going to do, I'm going to play the guy who's pioneering most of the stuff on campus. Can you see that okay? Yeah, let me actually make that a little bit bigger. And let's expand that. And there we go. Is a guy named Cliff Nass. He's technically in the communications department, but he's a heart scientist who does stuff with experimental clinical studies around neurobiological responses. Fascinating stuff, worth knowing about. And here's his kind of take on
The
what happened
idea
when we
that
looked
we
for
saw
multitaskers.
more and more kids on campus and of course all around the country multitasking. And if you look at classical psychology textbooks, they tell you people can't multitask. It's psychologically impossible. So on the one hand, we had this clear statement, look, people can't multitask. And on the other, we had people multitasking like crazy.
I think it's unrealistic to do one thing at a time, but it's just the way things are, you kind of have to multitask.
Thanks for coming in. So in this task, you'll basically be looking at different rectangles that are going to be presented. It'll be red and blue rectangles, and they either change orientation or they won't. And as soon as you brought in the high multitaskers, the more blue rectangles you brought in, the more distractions. Even though we clearly told them that these were completely irrelevant, they couldn't help paying attention to them.
We really don't know what's happening other than that they seem to like to be flooded with information. It's almost as if they prefer to scan the environment, just constantly scan and grab new information, rather than ponder what they have. We don't know whether there are advantages to that, but so far we haven't found any.
You a good multitasker?
I thought I was. I'm not so sure after this study, but I do listen to music and chat with my friends all the time at the same time.
To our absolute shock, we found that in any of the categories of activities that we thought their brain would be better at, that would enable them to manage multiple streams of information at one time, they're actually worse at all of them. So it's a great mystery what the heck is going on. Right now, what we can say is multitaskers are lousy at multitasking.
So it's an interesting phenomenon. There was a phrase in there called a distractor, which I'm going to come to. This is going to be the relevant piece of what happens, I think, in corporate environments under certain circumstances. And so one of the interesting problems, now this is a couple of years old, we do know a little bit about what's going on. What's happening is that humans are not good at multitasking at all, especially as you get smarter and more specialized in what you do. What you're actually doing is you're switching. You're switching back and forth. You're switching from one task to another, and sometimes you're doing it very, very quickly. The bad news for, well, in a weird way, the good news for drivers who don't, in fact, drive and talk on a phone is that the other drivers who are, in fact, driving and talking on the phone are really good switchers, meaning they can go back and forth from the other thing that they're doing and hence pay enough attention typically to the driving. But what's really interesting is that using some cool PET scanning imaging and technology, we've now definitively determined that when you're driving and talking on the phone, as it happens, the driving is technically the distraction, by the way. So the dominant light up is with the conversation. Turns out that driving most of the time is actually very semi-autonomous. You're almost doing it automatically. You don't have to think hard. But if you're doing anything other than a passive phone conversation, turns out it actually takes a little bit of bandwidth. So scary insights. But the way that this actually ties into what we're doing is, let's see here, F5, haha, is this next part. So I'm going to have you do something that's a little bit hard to do. I'm going to make you after lunch count things. So if you've seen this presentation before and you've done this little exercise, don't say anything because we want to see how good people are at tracking and counting, and we'll find out in just a moment. But I want you to kind of do your best at, let's see here, at counting. So the goal is to count how many times the players pass the white ball.
Count how many times the players wearing white pass the ball.
Okay, it's a trick. Uh-oh. That's not good. Hold on. Let's see
The
what
players
happens.
wearing white.
Let me try. Yeah, that'd be really hard. All right, well, we're going to watch it in the smaller screen. You ready?
Pass the ball. The correct answer is 16 passes.
How many got that? 16. All right.
Did you
Now-
spot the gorilla? For people who haven't seen or heard about a video like this before, about half missed the gorilla. If you knew about the gorilla, you probably saw it. But did you notice the curtain changing color or the player on the black team leaving the game?
This is
Let's
the real video
rewind
again.
and watch
It's
it
the same
again.
video you're about to watch.
Here comes the gorilla, and there goes a player, and the curtain is changing from red to gold. When you're looking for a gorilla, you often miss other unexpected events. And that's the monkey business illusion. Learn more about this illusion and the original gorilla experiment at theinvisiblegorilla.com.
So here's what's really interesting about this. So how many people saw the gorilla? That's a few. So it turns out that in crowds that are better at focusing, so if you get accountants, lawyers, neurosurgeons, certain folks who are good at being told, hey, look for this, they can like laser in on stuff, they are much more likely not to spot the gorilla, as it turns out. So it's a compliment to your professional skills that by and large, as a crowd, you mainly miss the gorilla. But here's what's interesting. So the white balls were a distractor, right? So the passing was a distractor, and it caused you not to see the really interesting stuff happening in the room. And this is pretty good, and it turns out to be robust metaphor for what happens in a lot of emerging compliance environments. So first, without spending too much time on it, it turns out that the brain scans about this stuff are pretty convincing. If you're multitasking or you're laser focusing, you miss stuff, right? It is the classic, you miss the forest for the trees and you don't see what's coming from left field. And it's very frustrating as a well-trained professional to have that happen to you. But it is more likely to happen to you the better off you are at handling the thing that's in front of you at that moment. It is a fundamental injustice of great professional focus, which is to say you finish the task well or complex set of tasks in front of you, and you don't see the thing sneaking up behind you and about to hit you over the head. So we resist this result, by the way, because it is fairly infrequently that we get hit pretty hard over the head. And so by and large, we don't have a lot of experience with it, though ask a bunch of general counsels in the Bay Area about option backdating, right? Or ask a number of general counsels right now about FCPA compliance. But we tend not to have this happen, so as a matter of experience, we don't have this notion that it's a big risk. But also, when it comes to the multitasking, and I'm kind of intermingling these two concepts, but they play a big role practically, I think, for people in this space, you just resist this notion of multitasking because, you know, and my job today, I have a whole separate presentation where I convince boards of directors not to multitask while they're deciding multi-million-dollar deals in the boardroom. My goal is not to convince you not to multitask, but it's to point out that, you know, as a practical matter, it's a real risk. Most of us are what we call multiholics. Next time, just for kicks, you get in an elevator, you know, grab your BlackBerry or your iPhone and pull it out, try to be towards the front of the elevator. About 10 seconds afterwards, look around. The majority of the elevator will be using their handheld device because we now know that use of PDAs is viral because it causes a funny impulse in your head. So here's a question, and if you did any experimental biology in college or high school, you'll probably know this answer. But of the 2 rat experiments that tried to fatten rats up, which one was more likely to fatten them up? The one where you press the little red button and a food pellet came every time? Or the one where you press the little red button and a randomized event would either give a food pellet or not give a food pellet? About a third of the time there'd be a food pellet. So how many people say the rats got fatter with the food pellet every time? See, I've set you up so you know. How many people say food pellet randomized? So what is a BlackBerry? A BlackBerry is like a little food pellet or a slot machine, right? There's a reason why slot machines don't give you a little bit every time. Right? I wouldn't suggest that the gaming industry arrived at this scientifically. They just arrived at this iteratively. You could give someone a tiny little bit every time just to keep them there. It turns out that doesn't satisfy a complex set of dopamine receptors and some other stuff where if you randomize it, we get a little hit of anticipation. So it turns out that most of us, especially professionals, catastrophic multiholics. By the way, now that I've said this, you have no obligation not to multitask during my presentation. If this were about directors, I would talk about fiduciary duties. Directors, during the meeting, have a fiduciary duty not to multitask. If you're an audience member, you know, it's my job to make you interested enough not to multitask. But after the fact that we acknowledge that we're kind of multiholics, you have this brownout problem, right? Which is to say, we see it with students. Students are so intent sometimes on taking notes that when you present complex issues, they're really just serving as a conduit to their fingers, and they miss stuff. How many people have ever been on their cell phone, headset, so not breaking the law, and driving on your way home, which a lot of professionals do, right? You cram in up until the very last moment, and suddenly you find yourself at your house. You're like, well, that was a short commute, right? Has anyone ever had this experience? So it is the effect of a cognitive brownout. So what happened was you were really focused on your conversation, and everything else essentially browned out. And this happens in a lot of environments. Oh, this is hard to see, so I'll tell you while I know what it says. So the reason you're still in denial, by the way, is you're pretty smart folks, and you have a lot of cognitive reserve. You can talk to your kids, email, and be on a conference call all at the same time. You're switching, right? Your brain's doing all sorts of crazy antics to do this. And frankly, you're kind of doing subpar in all three categories. But you know what? You're pretty talented. So half of your effectiveness is probably good enough at any moment. But it is the equivalent of saying, hey, go ahead and drive. You're a skilled driver. You hold your liquor well. So there's kind of a duty issue there as to whether or not you should do that. Routine tasks, by the way, don't require deep thinking, may not require your full cognitive attention. So, eating. Eating tends not to. It turns out, by the way, we have a great clinical experiment for this one with undergraduates, which you can imagine created all sorts of funny outcomes. But we can distract people while eating, and they get sloppier and sloppier. It's very interesting. But by and large, what you eat, when you eat, that's fairly autonomous. If you don't need to learn from it or remember, then you're fine. And this is very relevant to I-9 stuff. So here's the interesting point. A lot of work in the world of HR compliance is so routine and so repetitive that people become very good at the individualized task, right? Which isn't easy to do, by the way, but let's assume you become very good at the individualized task. Even lawyers monitoring the individualized task, and yet by doing so, you end up not aggregating any real knowledge over time about a particular data set. So the difference between processing data, there's a funny saying, which is your research assistant won't have any insights if they're really efficient. Why? Because they're coding data for you all the time. They're pulling articles. They're exposed to everything, right? And is it that the RA is not as smart as the professor? No. I am not distracted by entering any of the data. All I do is I sit back and I twiddle my thumbs until it's all ready. Then I kind of get to look at it. And so what's interesting is when you engage in this autonomous activity, you miss, by definition almost, the forest, which is something to think about. And then finally, let me set that. Oh, that was badly formatted from the beginning. There is this concept of mimicry, which is why you think you're better in meetings than you really are. And that is, I can't pull it up, but I'll tell you what it says. So the mimicry idea is that when you sit in a meeting or in a classroom, you know how it's kind of weird that you laugh at the right moments even though you were working on an email? Right? And you're like, oh, look, I can really multitask. No, actually you can't at all. What's happening is you kind of are listening, but what you're doing is you're cueing off of everyone else. So you're spending as much cognitive capacity monitoring what other people are doing around you at any given moment. This is such a big deal that in the, we've got, I think, a pilot in the room, or we did a while ago, like a serious airline pilot. But pilots have a whole concept around this. And when you're flying, it's crazy to think this, but you have a pilot and a co-pilot, there's an anxiety about who's actually flying the plane. Right, because you're kind of sitting there as if you're flying the plane and you're mimicking each other. So there's a formal handoff in aviation. You say, you have the controls, I have the controls, you have the control. You go back and forth 3 times to make sure that you have it. This happens in meetings of all sorts, in board meetings where, and I won't ask you to raise your hand, but you've observed this, I'm almost sure, in the last 6 months, I bet, where you're in a meeting, it's an important topic, it's on a busy day, you're all talking about various things, but some of you are writing notes, which don't have anything to do with the meeting. Some of you are looking at a handheld device. A couple of you might even have your laptop. And there will come a moment where you're not sure anyone's actually in the meeting. Because you'll all be kind of nodding or talking, and you're all, I get a laugh because you know that this happens every once in a while. So this kinds of things happens. And the reason this is relevant is I'm going to postulate that general counsels, CFOs, audit chairs of companies, this is not anywhere on their top 10 list, right? Unless they're already in trouble, I-9 compliance. And hence, even if you manage a meeting, you don't get their full attention, you don't get a lot of time, you don't get a lot of things, and they're going to multitask with the whole thing. So, what to do about it? All right. So, quick a side part of this. So, even lawyers learn how to spot, right? We learn in law school, but we have this weird problem where it's a learned attribute, the ability to spot an emerging issue. So it turns out that unless you're trained, you can't spot sharks or you can't spot dolphins in choppy seas unless you've kind of been trained to do that. Same thing with novice pilots. Novice pilots who tend to be younger, better eyes, more, less cynical, more tuned, trying to perform well. They don't spot other aircraft in the air nearly as well as older, more senior pilots with arguably much worse eyesight. And it's because of something that people who learn to spot things become good at, and it is avoiding distractors. So in the gorilla video, the distractor was the counting and the white balls. And Cliff Nass has demonstrated all sorts of interesting stuff that emerges around distractors and how people can be conned into things because of distractors. Lots of fun stuff. But one thing is that you have this negative target fixation, which causes you to distract yourself from important functions or other things, and you end up, if you're in a troubled plane with a bad engine and there's a big open field, you say, don't hit, and there's a big barn, right? You're like, well, just don't hit the barn, don't hit the barn, don't hit the barn. What's funny is by panicking about hitting the barn, one, you forget to fly the plane, so you're much more likely to crash, and two, you're more likely to hit the barn because of a variety of complex issues around fixating on a particular target. So what's interesting is when people spot a dolphin, they'll see a dolphin, right? Oh, dolphin, 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 but they miss the boat chasing it if you, quiz them after the fact. Here's the startling conclusion for companies. For the average publicly traded company, I talked to lots of them in the Bay Area and in other places, the #1 mantra response is, but we don't have any undocumented workers. But we don't have any undocumented workers. But we don't. And my observation about that is that's the distractor. I mean, it matters at a certain level, obviously, if you have employed many people who are not eligible to be employed, but that is the white ball being passed around. That's what people are counting, right? They're thinking about the undocumented worker as, ooh, look, I can count all that, but that's actually not the point, certainly not from a securities regulation viewpoint. So I'm going to skip this in the interest of time, and since a lot of you are practicing lawyers, there's a point about all this, which is I think directors now are on notice, or should be, partially thanks to the efforts of the Rock Center and me maybe, that they need to pay more attention to certain issues of risk, and this is on that list, right? So the auditors, the Big Four, are finally adding, immigration compliance to one of their Section 404 evaluative areas, so that's good. But directors actually have an obligation here, and so if you work with directors, you get access to general counsels who are advising directors of publicly traded companies. There is the possibility, I would suggest, that directors are allowed lots of latitude in making big mistakes in business. It's called the business judgment rule, and it's a good thing, right? We don't want the judiciary second-guessing business decisions, even if they turn out to be awful. That's under the duty of care. The duty of loyalty, which is the other primary duty, has more complexity to it, arguably, and there's no business judgment rule. It's typically conflicts, self-dealing, hand in the cookie jar stuff. But there's one part of it which has really emerged more prominently from the Delaware courts, and that is this notion of good faith, right? So you can be so derelict that it's not about making a business mistake, but it's about purposefully doing the equivalent of taking a nap during the board meeting or showing up drunk, right? And so that crosses a line in which you're engaging in bad faith. And so if you have bad faith, it's not about duty of care anymore. It's about duty of loyalty. And so you really do, as a director, have a lot more exposure. And one of the places where that comes up is scrutiny of what directors thought they were asking questions about. So if you debate whether or not to acquire another company, and you do acquire it, and it turns out to be just awful, that's clearly a business judgment, right? I mean, you might have done it well-informed or not so well-informed, but let's assume you talked about it and you actually made some sort of modest effort to make the right decision. If you knew that you were running a commercial, franchise that sells fast food nationwide, and you read any newspaper printed in English, and you never, ever ask your board, you never ask your management about I-9s, we can show definitively that it never occurred to you to ask somebody in management about this I-9 thing that has shown up on B3, B1, A1, top of fold, New York Times. It's the third most cited thing in New York Times last 10 days. If that never occurred to you, that's probably bad faith, actually, which is a startling thing to say to directors. So I mention that because it changes the liability. So where we've had bad faith efforts by directors or by plaintiffs' lawyers and others is in option backdating. It was kind of like, really? You didn't know? It's not a lot of inroads there, as it turns out, right? Because there's a tremendous amount of deference by the board in these what would be called paperwork issues. to the advisors. And if you defer to an advisor, you're protected by and large, so long as you weren't bluntly ignorant. FCPA is now coming up. If there's some big FCPA problems emerging for companies starting now, and the board never engaged in any effort to try to understand what the company was doing to manage FCPA risks, I'm going to suggest that there may actually be some sort of exposure that's going to get at the bad faith idea. And then finally, I-9 compliance. So this is all complicated by the fact that directors and managers and companies as a whole engage in much more nuanced shareholder communications than they used to. There used to not be as much pressure to do so, but now there is. And so there's information going out, compliant, right, under Reg FD, which means you can't just tell it to one party and not another, not just the analysts. But information that's going out from a company to the investors at large. And this matters now because of the communications issues around I-9s. And then there's also the risk of deliberate wrongdoers. So now we know that you can be a director, you can be a CEO, you can be a senior manager, and you could have wrongdoers in your midst. It is clearly bad faith never to ask, do we have a financial cash control system? So our company, it mainly collects its money cash at cash registers. If no one ever asked or was never presented with some sort of method by which the company actually takes steps to make sure that the cash is tracked and deposited, right? Because it's fairly obvious there are incentives for frontline individuals without controls to engage in self-enrichment. Well, we now know that there are incentives for HR professionals at frontline environments to engage in self-enrichment through fraud and other things. I mean, so this is, maybe it's not quite as obvious as people reaching into the till, right? But now there are lots of scenarios, examples, and facts where it's been clearly demonstrated that that's a known risk, right? If you have a particular profile of employees in your company and you have a profile of HR professionals at the front line and you have a far-flung empire, you should have at least asked the question, so, like financial controls, like inventory controls and pharmaceuticals, have we done anything to make sure this isn't a really big problem? That's the threshold. It's a pretty low threshold, right? As soon as the director asks that question, you probably dodge the bad faith problem. But a director who ignores the risk of a bad actor in the environment, I think will blow the bad faith threshold. So what are people getting sued for generally? So how does this tie to all the securities litigation that I mentioned? Well, securities litigation, explained in detail, is catastrophically boring, so I'm not going to go there, other than to point out that you've got kind of two big boxes, right? You have private plaintiffs, so federal securities suits, state law derivative or fiduciary duty suits, you've got creditor suits, and you've got employee suits and ERISA suits. So here's the mind-blowing part. So I-9 compliance as a general area triggers three of those, everything but creditor suits, right? You can generate federal securities, misrepresentations, fraud in the market, you name it. You got state law derivative stuff, that's easy, right? If, same blowing of the same issues as under the federal security suits. And then employee suits kind of go hand in hand. It's not exactly the same cause of action, but if you look at Chipotle and others, when you're compelled to take action, sometimes quite rapidly, on the kind of unlawful employment side, then unions are going to step up. Plaintiffs' lawyers representing employees are going to step up. So you end up kind of triggering three of those four. There's very few areas that trigger more than one or two of the private plaintiffs' action side. And then on the government side, you have the SEC, that's obvious in civil, other federal agencies, but you trigger this one as well, of course, because of DOL. You've got the U.S. Attorney, we'll hear more about that, state enforcement agencies, civil and criminal. I can't emphasize enough how extraordinarily challenging it is to realize that with E-Verify thrown into the mix and with Supreme Court ruling on Arizona's E-Verify employment environment and licensing regulatory approach, right, which is why it survived in part on the 5-3 decision, state and municipalities now play a role. So if you're operating large facilities in a place like Arizona or Mississippi or any number, or Alabama coming up, and you never pay any attention to some of these emerging issues, you have potential government players who show up at your doorstep, and in Arizona's case, after one warning, just kind of shut you down. And then finally, foreign governments. It's the only one that doesn't get triggered. So in these two big boxes, and when we go through risk assessments for boards, the Rock Center gets pulled into board meetings, and we pull this up, and we break it into lots of charts. It's surprising to have a topic of interest that triggers more than one or two in any one of these categories. So 3 out of 4 in the top, 4 out of 5 in the bottom. It's really quite surprising. So what does I-9 compliance have to do with securities litigation? Section 404, which is from Sarbanes-Oxley, is an internal controls provision that says, as a matter of process and as a cost that you're going to pay your auditor for, you have to show us anything that has real impact on your financial well-being, directly or indirectly, reputationally or otherwise, and evaluate it for whether or not it is correctly set up, if it actually represents robust and reasonable controls. Then you have the whistleblower provision, which recently we have the now proposed regulations as of about a week and a half ago under Dodd-Frank, and I'll give you the details of why these two things create a tremendous opportunity for liability and litigation for publicly traded companies. So the plaintiff's bar, any plaintiff's lawyers? I like plaintiff's lawyers, I'm not, okay. I mean, the plaintiff's bar is relentlessly creative, and I say that with admiration, right? I mean, the plaintiff's bar pays attention to the wrongs that are done to investors and others, employees and others, and looks for new ways in which they can hold corporations to account. It's just the way it is. Whether or not you like that or don't like that, it doesn't change the fact that plaintiff's lawyers are extraordinarily well incented not to miss the gorilla, right? As a practical matter. They're kind of searching, they don't count stuff, they're looking for changes in the way the world works so that they can identify the emergent liabilities, particularly the good ones. Markets may be entering a phase, so there's going to be more volatility due to nuanced information. The markets seem to understand immigration liability better now. It's taken a while, but Chipotle might tip the balance where now analysts, so we track analyst commentary about immigration matters, very, very little until the last 9 weeks. And so now analysts are making observations about publicly traded companies that aren't Chipotle and talking mainly about their labor costs, right? So they get at it in a way they understand, which is, aggregate labor cost trends. And they say, gosh, they might be exposed to immigration issues, and that might get them in trouble with the government, comma, and this will have an impact on their forward-moving labor costs. But the fact that analysts now notice this means that price sensitivity, which is important for certain types of litigation, price sensitivity is going to increase relative to immigration news. This is very bad news from a liability viewpoint for a company, because once upon a time, if you disclosed that you had an NOI and it hadn't gone well and your Philadelphia facility had to lay off 27 people and you're settling and you're paying a fine, markets were like, Now, if Philadelphia is one of 78 facilities and your smallest one, you have the exact same hiring and patterns and practices at all the others, and you're super sensitive to disruptions in your labor force, and you're publicly traded, that announcement is going to get picked up probably. They're going to analyze it for impact, and your stock price is going to change downward. And if it changes downward, you have the elements of a fundamental cause of action under certain types of litigation. So then there are reasonable parallels. What's funny is we've been studying this stuff for a long time, but in the SEC world, where the SEC does stuff that looks a lot like NOIs, where they kind of show up and they say, we're doing an investigation, and they explicitly say, it's up to you, the target, you love that, right? It's up to you, the target, to disclose this to your shareholders if you want to, right? We may issue you a Wells notice, at which point in time you kind of have to disclose it, but until then, it's up to you, and it is complicated, right? These things could go nowhere, and so you don't want to disclose, and so there's a lot of academic research that has gone into disclose or not to disclose. Here's the punchline. You don't have to read the 17 articles or spend the few days. The punchline is the market seems to know if it's serious. So the market discerns a Wells notice that is a surprise, meaning they never disclose the investigation, but ends up not going anywhere. The market is less responsive. So it seems that the market interprets the seriousness of the matter pretty quickly. And so the fundamental lever for the I-9 world is, do analysts and shareholders believe that ICE is getting tougher? And if they do, these announcements will matter more. And then finally, there's been a big uptick, which is to say kind of around 0 5 years ago, to arguably 3 or 4, depending how you count them, not counting state actions or kind of novel plaintiffs' actions that include it as one of more than 5 or 6 items. But there's now 3 or 4 arguably pieces of litigation, American Apparel and others. So what does it have to do with whistleblowing? So whistleblowing, there's whistleblowing in Sarbanes-Oxley, right? It's fairly narrow, though, and it's got some retaliation protections. But now Dodd-Frank, it's in comment now, so you can provide comments. It's not final. It's just proposed regulation. It came out on May 25th. And basically it says it enables a whistleblower to obtain a bounty, uses that word, kind of Old West, where he or she voluntarily provides the SEC original information that leads to the successful enforcement of a federal court or administrative action where they obtain more than $1 million. The bounty itself is 10 to 30%. So, if you had discovered Enron with independent information, wow, You'd retired very, very wealthy, right? So this will have an effect. We've studied Ketom proposal. We've looked at a lot of stuff at Stanford about what do individuals do when confronted with whistleblowing bounty, and the answer is they respond. Right? I mean, they do tend to pay attention, and you do get action. Whether or not it's super productive is a complicated matter, but you get action. So even if a whistleblower turns out to have provided insufficient information, either it lacked sufficient credibility, did not have sufficient evidence, or it's dropped as a matter of public policy, they're still protected under the whistleblowing anti-retaliation provision, which is really interesting, right? So this was a little bit unexpected. And importantly, they explicitly expanded on the fact that during this process, you can't hinder the whistleblower's access to the SEC. You can't stop them, can't harass them, can't do anything. So in certain circumstances, this is the eye popper in a way, but I wouldn't lose sleep over this because the lawyers in this story can't really do this. But there's a phrase, without going into too much detail, that seems to imply that if compliance is your internal function and you end up whistleblowing about a failure of compliance around the job that you do, that you may not be eligible. But it was clarified, and there's 2 points in the world of I-9s. One, an HR professional, I don't think would be covered by this, because if I-9 is one piece of what they do, it's not their full compliance function. So they're not going to be prohibited from participating in the whistleblowing. Even if you go up the chain, you have a big enough enterprise and someone, half their job or 3/4 of their job is I-9, there are exceptions for actual internal audit personnel or compliance personnel and public accountants, which detail that if you think investors are in the process of being harmed, you may whistleblow and participate in the bounty. So there are unusual exceptions relative to most whistleblower provisions that allow those who are in positions of trust and have deep information to participate in whistleblowing, which is a little bit unusual as compared to the previous history. And a quick distinction, which again, I would officially put you to sleep if I went into this too deeply, but the bar for securities shareholder class action lawsuits is pretty high, right? All things considered. That happens all the time. Any M&A now, about 8 minutes later, you've got a lawsuit filed. But for most things, it's a pretty high bar because you've got to have stock price movement. You've got to have a lot of things happening. You've got to have materiality in the representation. So it's a fraud action, right? Well, and that bar was probably met, and it's underway in American Apparel. Because they said, no, we're taking care of it, no worries, no worries. Right? That was wrong. And they probably knew, so it was a material misrepresentation to the market. However, the books and records requirements for publicly traded companies, which speak to matters of basic accounting and record keeping, and I think when the argument is made, I-9 paperwork is going to be considered basic accounting and record keeping, right? It'll be in the record keeping part. The books and records side of this does not require materiality. It simply requires reasonableness. So it's a completely different, much lower bar standard. Plus, this idea of the whistleblower. So you combine the fact that you don't need an independent class action lawsuit. You need a whistleblower who goes to the SEC and says, this publicly traded company is in violations of the books and records requirements, and doing so opens them up to surprise and damage later, which is bad for investors. And if you add that to the political sensitivity around these issues generally, I don't think we can ignore the politics. You really do, I think, have pretty good fodder for moving forward on a lot of things. So last 3 points about discovery. So there's been an explosion of technology throughout all enterprises in the last 10 years. I don't have to tell you that. But what's funny is the technology in the record keeping has far exceeded the formal processes. So people tend to onboard folks electronically now. Or they take resumes. No one takes paper resumes that I know of anymore. They take them electronically. What's funny is the discussion, the careful work around the process of that has lagged behind the depth of the technology. And so what happens in a good day is this is kind of a safety net, right? Someone says, I'm worried that our site in Yuma has been discriminating in the way they're selecting second stage interviewers. Well, the GC can go into the onboarding system and pull up all the resumes and do a system. So that's a good thing. It's kind of a safety net. But on the other hand, it inadvertently captures what we call the full chatter of the enterprise. So every email, every instant message, everything that went back and forth between the lower ranking HR people and their peers, all the way up. So if you're a lawyer, you know that the telephone is a useful object sometimes, right? I've written something on email, I'm like, I'm gonna call them, right? Because you think to yourself, that E stands for evidence and everywhere. And so, but a lot of HR professionals, especially lower ranked, younger, first job, second job, and maybe it's a good thing. They're not cynical, maybe it's a good thing, but by and large, they don't think about that. And so you find instant messages or chatter that goes something like, yeah, well, I don't know. I figured this one cost $75. It looked pretty good to me. That would be the ID, right? So you end up with really interesting chatter built into the environment, which probably happened at some level before, but the emergence of the dominance of digital communication, it's there for, I see the US attorney, I'm worried she's gonna start taking notes here. It's there, people don't realize that they're instant messages, in almost every publicly traded company. They're archived. They have to be, right, under Sarbanes-Oxley. So this permanence and discoverability is a way of life. Steve Cutler of the SEC, before he left the Division of Enforcement, said in a great speech here at Directors College a few years ago, he said, my favorite thing about the late 20th century? He says, email. It's 20th century's gift to law enforcement, right? He says it's just the greatest thing. And he meant it, and then he cited a lot of examples. A lot of folks don't realize that how many people have been on a webinar type, where it's not live video, but it's like a PowerPoint, something, a webinar in the last few weeks? So how many people, as a participant, not a presenter, it might have been our webinar, and I will take no offense to this answer, how many people, how to put it gently, engaged in other tasks that required more immediate attention during certain parts of the webinar, like checking your email, for example, right? It's okay. So did you know that webinars, most current webinar systems, WebEx, GoToMeeting, if the kind of host pays for the higher level licensing, tracks your attentiveness, including which window's in front, right? So that if we go into the metadata, I can find out that you never had that window on your front window, that there was always a window obscuring it, right? So, and actually on the higher end systems, they score you as to overall attentiveness. This is actually now being kind of litigated and played out in an unusual way. If you're from California, you know that if you're a manager and you do sexual harassment training of 2 hours every other year, you get a certain sort of safe harbor in certain circumstances. But now, of course, it's in the interest to demonstrate if perhaps someone really wasn't paying any attention, so they shouldn't get that protectiveness. And so you go into the webinar, you say, look at that, 27 other windows open. This one spent 6 minutes of 123 minutes as your front window. Don't think you really participated, right? So these issues will actually start to come up. And I mention them for things like Illinois, training over E-Verify, right? So if you use E-Verify in Illinois, you have a few extra issues to which you need to pay attention. And some of it has to do with training and attentiveness. How does that get managed? Could someone look at that later? Yes. And so what's funny is using a critical eye to the company's chatter profile around issues of workplace compliance is critical, and I know of no one who does it. It's hardly a best practice. I would say it's not a practice at all, but it's something that we do in securities. We do it in other enforcement actions. We do it in white collar. I mean, this is a question that good lawyers ask their clients and say, so listen, what stores of records do you have that would reflect to a critical eye negative behavior in this arena? I'm not saying you did it, but anybody. Where do we look? How can we see that? This tends not to come up. So I'm not going to belabor because we're talking about it in other places, but Chipotle Mexican Grill will be a case to watch because there's a lot of shareholder dismay around this, and I think you already see kind of the employee side turning litigious, but we will now see, I think, some stuff. What slowed people down is this annual report disclosure. It's like, listen, we have big problems, can't solve all our problems. But what's interesting is the disclosure is probably not fully protective. If anything, it might set the stage for saying, okay, so you knew, can you please show me what you did at senior levels to talk about or mitigate this? And if there's nothing, I think the directors will have bad faith. And I mean, because it's in the annual report, right? So if this conversation didn't happen at the top level, there's going to be a big problem. And it's yet to be seen. Question? Say that again? So it's now more common, and I'm trying to think who's following. Like Eric Board has followed this stuff. I mean, there's some people who've kind of followed this. It was completely uncommon 5 or 6 years ago. I think now fast food focused and certain types of retail and processing plant folks, ever since some of the big meat packing litigation, have started to insert this into their internal. I would say less than 5% of publicly traded companies have something like this. Yep, yes. Yeah, this will show up either in the annual report, or if something happens, they'll stick it in the 10Q, or they'll put it in the 10K, obviously. And it's interesting because I think one of the problems in the Bay Area, again, it's the second response after, but we don't employ anyone who's undocumented, right? That's, of course, the white ball, not the gorilla. And then they say, plus, we don't don't process meat. I mean, I get that line so much. But of course, you just run the numbers. If there are 1,000 to 3,000 NOIs issued every year, and the administration makes a generalized comment that says publicly traded companies are important in this story, and you only have, if you count them all, 7,800 publicly traded companies roughly, right, that aren't not trading, but like liquid publicly traded companies, and you say that only 30% or even 20% of the NOIs will be directed at publicly traded companies, you hit all the publicly traded companies in 6 years. There's no way to avoid that, right? So any publicly traded company that says, well, we don't worry about this because we're not in the right category is, oh, are you going to delist next year? Or, I mean, what category are you not in? Which is to say, visible publicly traded company. And I would say it was reasonable 3 years ago to say, listen, that this is not us. I'm going to worry about that and pigs falling from the sky and squishing cars in my parking lot. I understand, there's a tiny little risk, but the profile of exposure has fundamentally changed. So American Apparel, same thing. I don't need to go into that, other than to point out the reason the litigation happened fast and furious is, one, I think American Apparel engaged in a sort of, hey, bring it on sort of thing, which backfired, right, and didn't go well. So there's a problem there, but also massive stock price drop, right, which just begs for the traditional securities class action litigation. So what to do right now? You know this, I'm preaching to the choir. Treat I-9 and related compliance areas as if they are a critical control function. It's an attest, it's a sworn statement lurking in your paperwork for which you must complete one for everybody. There just aren't too many things like that. It's crazy, right? So treat it like that and say it that way to your GC or the CEO or the CFO. Say, yeah, there's this thing. Every employee's been going around signing it, and it makes a sworn attestation to the federal government. And then one of our employees has been joining on right afterwards, and they've made this sworn attestation also. And then they write down numbers from documents. It is crazy. And we've got thousands of them floating all around the company, and we don't know what to do about it. They'll be like, who allowed this to happen? It's like, that's called an I-9. And everyone fills them out. And so if you use the descriptive and not what it is, they freak out. Obviously, I don't have to make a living by getting large corporations to pay me money, which you may have to do, so for which probably shouldn't do what I just described, but it's kind of fun for me to tease them. And then engage in an internal process, a la books and records and policy analysis, just like you would for a books and records FCPA issue. Someone should dive in and say, so do we treat this like the really important thing that it is? And if the answer is no, bad news is you're going to spend a lot of money on somebody, right? Combination of outside counsel and McKinsey, or you're going to have to do whatever you did when you found out that your accounting reconciliation in the late 80s had not fully transitioned to electronic, and you freaked out because you found out there was $80,000 embezzled in one of your little stores out in the middle of nowhere. You probably spent more effort fixing that than the entire enterprise has ever focused on I-9s. And that will come out someday. And then finally, get the attention of the CFO, the GC, or the audit chair. Send them to Directors College. I don't know, do what you have to do, right? But get their attention. And then back to this whole, oh, we're not that kind of company. Just end the denial. I mean, it is humbling. And I know, again, I'm preaching to the choir, and you're trying to get everyone to end the denial, but it's just not happening. I know that. But really, it is. If one more board member says to me, I-9s, isn't that just paperwork? We don't pay attention to any of the paperwork. I said, yeah, it's paperwork, 8Qs, 10Ks, 10Qs, yeah. It's paperwork. It's a sworn attestation provided to the public for purposes of making better investment decisions, asterisk, and if you provide bad faith, you get to pay out of pocket when the litigation ensues, right? So, I mean, it really is serious, and it's kind of our job, I think, in the kind of corporate governance world, maybe to bring more attention to it, but it's going to be a long haul, I think. But I think it's going to change. I think the next few years are going to be a big change. So I've gone over by 8 minutes, but I'll do 2 minutes of questions if there's questions, but I'm also hanging around, yeah? Well, so switch hats. Don't be a securities lawyer and instead be an immigration lawyer, and you're like, oh dear. Yeah. Yes, right? And so it's one of those things, damned if you do, damned if you don't, because they either had constructive knowledge that goes all the way to the board, or they had bad faith at the board and constructive knowledge farther down. Oops. I mean, that's a bad spot, right? So what's much, much worse is if you are like Chipotle, and then you have this a year from now, that's much, much worse because you're like, so, didn't read the paper at all? I mean, really? I mean, so I think it's going to be worse for whoever's next. Question in the back. Yes. It's trickier for you as outside counsel to say this, I think, but I think with enough information you might be able to say this quite credibly. And here's what I do to get people to pay a little bit more attention. I say, well, it really feels to me like the FCPA issues a couple years ago. That gets general counsel's attention very, very quickly, especially if they have foreign operations, right? So, people like just information technologies, non-manufacturing, information technology companies, I'm trying not to name names, information technology companies who think of themselves as not manufacturing stuff. So go back 5 years, and if you didn't build stuff, basically in Taiwan or PRC or other places, if you didn't actually manufacture stuff, you just weren't thinking about FCPA, right? And the information companies would say, well, yeah, we got operations, but we don't do that stuff. Well, fast forward to now, and it turns out that giving flowers, and lots of them, to that Vietnamese regulator so that they would open up internet access to their people for a particular type of social networking product, not Facebook, really, turns out to be an FCPA violation, right? I mean, a serious one, maybe. And so I think it is dawning on technology companies that don't make stuff. So there is a very particular type in the Bay Area. If they don't make stuff, they just don't think they have immigration issues. Like, that's for manufacturers. That's for food processors. That's for retail food outlets. That's not us. And so you say FCPA. It's like FCPA. And they go, right? Because that's starting to panic them. That's second best. I haven't. If you figure out something, let me know. I mean, I do this a lot, which, it gets me invited back. I don't know if it's getting anything done. Any last question? All right. So we have, we'll take let's start at 2:05. Take 11 minutes, and we will start our next session in about 11 minutes. Thank you very much. It gives you a chance to refresh your drinks, and otherwise, thanks.